Hello everyone, I'm Celia. From Beijing Lavok's Intellectual Property Agency, and today I'm going to tell about the Chinese patent process. The process of invention patent application can be divided into 5 stages: acceptance, preliminary examination, publication, substantive examination, and grant. First, acceptance stage. After receiving the patent application, the patent office will examine it. If it meets the acceptance criteria, the patent office will determine the filing date, give filing number, and after verifying the list of documents, issue a notice of acceptance to inform the applicant. If the application document is not typed, printed, or handwritten, or has been allotted, or if the drawings and the pictures are not drawn with drawing tools and black ink, or the photos are blurred and are altered, or if the application document is incomplete, or if the name and address of the applicant is known in the request, or if the category of patent application is unclear or uncertain, as well as the foreign applicant send the patent application by himself, not by patent agencies in China, shall not be accepted. Second, preliminary examination stage. If the application fee is paid in accordance with the regulations for the patent application after acceptance, it will automatically enter the preliminary examination stage. The invention patent application before the preliminary examination shall first undergo a confidential examination. If it needs to be kept confidential, it shall be handled in accordance with the confidential procedure. If the preliminary examination it is necessary to examine whether there are obvious defects in the publication, including whether the content in the examination and acceptance falls within the scope of non-granting patent right in the patent law, whether the obvious lack of technical content cannot constitute a technical scheme, whether the lack of security, whether the application documents are complete, and whether the format meets these requirements. If a foreign applicant, he or she should also undergo qualification examination. If it fails, the patent office will not notify the applicant to correct or state his opinions within the prescribed time limit. If it fails to respond with the prescribed time limit, the application will be deemed withdrawn. If the defect has not been eliminated by the reply, it shall be rejected. Third, publication stage. The invention patent application will enter the publication stage from the issuance of the notice of eligibility in the preliminary hearing. If the applicant fails to make a request for early publication, it will not enter the public preparation procedure until the expiration of 18 months from the date of the application. If the applicant requests to be made public in advance, the application shall immediately enter the public preparation process. After format review, editing, and proofreading, computer processing, time setting, and printing. About 3 months later, the abstract of instructions will be published in Patent Gazette. and a single-line version of the instructions will be published. After application is published, the applicant has the right to temporary protection. Fourth, substantive examination stage. After the publication, if the applicant has made a request for substantive examination and has taken effect, the application shall enter into this stage. If the applicant has notified a request for substantive examination for 3 years from the application date, or if the request for substantive examination has not taken effect, the application shall be deemed to have been withdrawn. There is a period of substantive examination, novelty, creativity, practicability of patent application, and other substantive documents stipulated in patent law will be comprehensively examined. If the applicant is found to be incompatible with the conditions granted or has various defects after examination, she shall be notified to state his opinions or make amendments within the prescribed time limit. If he fails to respond within the prescribed time limit, the application shall be deemed to be withdrawn. If the application fails to meet the requirements after repeated replies, it shall be rejected. If no reason for rejection is found in the substantive examination, the procedure of the grant shall be carried out in accordance with the provisions. Fifth, grant stage. Where the reason for rejection are not found after substantive examination, the examiner shall give a notice of granted. The applicant shall follow the notice within 2 months after receiving the notice, where the rejection formalities are required and the prescribed fees are paid, and if the registration procedure are completed on time, the patent office will grant a patent right, issue patent certificate, record it in the patent register, or publish it in the patent gazette 2 months later. If the restriction formalities are not carried out in accordance with the regulations, the right to obtain patent right shall be deemed to be abandoned. Advice publication of invention patents. The so-called early publication refers to that the applicant may request the patent application to be published in advance and shall submit an advance public declaration from the filing date and priority date of invention patent. Advantages of publish patent in advance. Firstly, early publication on the publication will enable the applicant to obtain the provisional protection provided for in the patent law as soon as possible. Secondly, it may play a certain role in helping the patent enter and occupies the market in the future. The shortcomings of the patent publication in advance are as follows. If the content application is published too early, others may make use of the application, which may harm the interest of the applicant. Every time period can be published in advance after passing the preliminary examination by the patent office. It can enter the publication procedure immediately. There's no requirement for the time patent application to be published in advance. Okay, that's all. See you next time.